A very good morning to all. Today, let us discuss a very important case Metal Syndicates and Others versus Union of India and others. This judgment was given by the Honorable High Court of Guwahati. Here, the subject matter was input tax rate cannot be denied to the bona fide purchaser for the seller's failure to deposit tax, a very important judgment which all of us are facing as we are getting the notices for the seller's default in deposit of the GST to the government. This judgment will help you to defend your case. Let us understand in detail. The High Court has set aside the demand of GST interest and penalty imposed on the petitioner. The court affirmed that the input tax rate cannot be denied to a bona fide purchasing dealer solely because the selling dealer failed to deposit the tax with the government, aligning with the previous High Court pronouncement and the Supreme Court's dismissal of the related special leave petition. The impugned action, the Assistant Commissioner confirmed a demand of around 78 lakhs for the period July 17 to March 19, along with interest under the Section 50 of the CGST Act and the corresponding provisions of the HGST and IGST Act, and imposed a penalty of 100% under the Section 74, subsection 1, read with Section 122 of the CGST Act and Section 20 of IGST Act. This order was subsequently upheld by the appellant uh, Additional Commissioner Appeal. The petitioner's argument. Let us understand the petitioner's argument. The petitioner contended that all the GST returns were filed timely and ITC was claimed strictly in accordance with the Section 16, subsection 2 of the CGST Act after fulfilling all the statutory conditions, including actual receipt of the goods and payment of GST through the banking channels. The denial of ITC was based solely on allied failure of the supplier to discharge their tax liability, a circumstances beyond the petitioner's control. It was also argued that the Section 73 and 74 of the CGST Act could not be invoked as the time period for the assessment has expired, and clubbing multiple assessment years for the consolidated order is impermissible. The core question of law: can the input tax rate be legitimately denied to the bona fide purchasing dealer solely on the ground that the selling dealer failed to deposit the tax collected with the government, despite the purchasing dealer having complied with all the statutory requirements? The key legal findings: the denial of input tax rate for the seller's default. The court relied on the divisional bench judgment in the National Plasto Molding versus the State of Assam, which in turn considered the Delhi High Court decision in the Kush Merchandising India Private Limited versus the Government of NCT of Delhi. The bona fide transactions: a purchasing dealer who has bona fidely entered into the purchasing transactions with a validly registered selling dealer, issued tax invoice, and shown no mismatch in Annexure 2A and 2B, cannot be denied ITC merely because the selling dealer failed to deposit the tax collected. The burden. The provision analogous to the Section 16, subsection 2, Class C, and Section 16, subsection 2, Class D of the CGST Act place an impossible and onerous burden on the bona fide purchasing dealer if interpreted to require them to ensure the seller's deposit the tax, department's remedy. The department appropriate course of action is to be proceed against the defaulting selling dealer to recover the unpaid tax rather than denying the ITC to the bona fide purchasing dealer unless collisions between the dealers is established. Supreme Court affirmation. The High Honorable Supreme Court dismissed the special leave petition against the on-Kust Merchandising India Private Limited judgment, thereby affirming the principle that the bona fide purchasing dealer should not be penalized for selling dealer's default. So this is a very important judgment. What the ruling, let us understand what the ruling was. The outcome was that the court set aside the order given by the additional commissioner appeals and quashed it, directed no specific directions to the officers were mentioned other than setting aside the order, implying a reversal of demand and penalty. Liberty, the respondent authorities are granted liberty to proceed in accordance with the law if there are material indicating that the transactions in the questions were not bona fide or were entered into in the collusion with the suppliers. Let us now decode this case law to understand further what the court wanted to say. The court wanted to say if there is no collusion means if you are not having any understanding with the supplier. For example, if you are a party to the fraud and you want to default the government, then this remedy is not applicable to you as you are the party to the transaction and you cannot expect remedy under this case law. So first you have to check whether the transactions was arm's length transactions. It should not be a related party transactions. If the related party transactions, then it is very difficult for you to establish that there is no collusion. Why? Because it will be assumed that the related parties are knowing about the transactions and there is no remedy for them unless it is proved otherwise. So here the main thing is there should not be any collusion between the supplier and the buyer. The second thing is there should be valid documents to prove that the transaction has taken place, like the purchase bill, then the movement of goods between the seller and the buyer, e-way bill, the lorry receipt, etc., which should prove that the transaction has genuinely taken place and there is no fabrication in the transactions to pass on the ITC. If this is proved as per section 16 subsection 2, then the court will give remedy to you as given in this case. Hence, it is a very important case. If you are facing this type of issue, you can quote this case law and get appropriate remedy. Thank you very much and subscribe to the channel if you like the content.